Item number 3. After 2 weeks.
On the other side.
3 with 4.
You are for? Respondent number 2. Respondent. You have informed the other side. Yes, I mean.
No, sure. Maybe they have informed Mr. KK Mohanto.
KK Moss, already I-
But what about item number 4? I think there
Koshi Gasile. Yes.
there
Someone
appears
has to be
to be some
appointed.
necessity.
Oh, yes, my lord. To appoint somebody.
Yes, otherwise after 2 weeks again same thing will happen.
Yes, my lord. Apa police niki samsung.
That's an order of side. I know, I will give, I know.
Oh.
Echo-
Eke niki accused, co-accused.
echo accused
Oh.
of murder.
That is jail appeal.
My lord.
Order টো চাওঁ, সেইটো লগত চাওঁ আৰু লিষ্ট আছে যদি কিবা চাওঁ। পেপাৰ বুক ৰেডি নেকি?
Paperwork ready, my lord.
Paper book was received on behalf of K. Goswami on 12/5/2023.
And thereafter he became, he was elevated.
So what do you suggest?
Now, should amicus curiae be appointed and from the panel?
এনেকে এইটো লিখো। This criminal bill
লিষ্টখন আছে নেকি?
has been listed today for hearing
এখন লিখি দিওঁ।
along with another criminal bill, criminal appeal number 164/2009. Without order separate court to without order separate court. Arising out of the same judgment and order dated 13/12/2018. Passed in sessions case number 77 within bracket and stroke 2017.
আৰু এখন হৈছে
Post of MS B. Bhuya,
online.
learned additional public prosecutor, has pointed out
চাওকচোন,
that
এখন লিখি আৰু এখন আছে নে?
Mr. K. Goswami was earlier appointed as amicus curiae by an order dated 4/6/2009. And since Mr. Goswami has been elevated to the bench, there appears a necessity to appoint, to engage another amicus. Post office. Thank you. Thank you. Okay. In view of such development, Srimati Vijita Sharma
Yes.
is appointed as amicus curiae for this appeal. Post of as such, the registry to this case again after 2 weeks by reflecting the name of MS Vijita Sharma as amicus curiae in the cause list. Post of a copy of the paper book along with other relevant papers be furnished to MS Vijita Sharma within 3 days from today,
Right.
in a week from today. It will go. It will be number. MS HM Fukon, learned counsel for the respondent number 2. Come out with the consent of the learned counsel for the appellant, comma, has prayed for listing of this appeal after 2 weeks. Full stop. MS B. Bhuya, the additional public prosecutor, has submitted that apart from the prayer of adjournment, comma, in the other connected writ appeal, comma, criminal appeal jail 33, 2019, a new amicus has been appointed, comma, both the appeals be listed after 2 weeks. Post of the prayer made on behalf of the respondent number 2 is allowed. List this appeal along with criminal appeal jail 33/2019 after 2 weeks. Yes.
I prefer listing middle appeal along with a interlocutory application matter for bail matter.
Interlocutory
Matter.
interlocutory is a file.
Yes,
It will be
madam.
listed then. It will be listed. 389.
Yes, madam.
It will be listed then.
Not listed that I mentioned.
Pursue the before the registry. Yes. Two. Okay. Oh. You are for whom?
I am for response number 1 to 5.
Okay, 1 to 5. This is appeal against equity, Lord Father. Yeah, Mr. Yu Chaudhary. Learned counsel for the respond number 1 to 5. What is your prayer? Memo key is the making. That's prayed for a listing of the appeal after 3 weeks. It is submitted that consent has been taken from the learned counsel for the appellant as well as respond number 6 to make the prayer. Full stop. MS P. Bhuya, learned additional public prosecutor who is in attendance, comma, has agreed to the sector in view of the consent given by the learned counsel for the other sides. So, full stop the prayer. As prayed for, leave the case after, leave the appeal after 3 weeks.
Taking this for hearing, item number 1.
As per office note,
Yes, my original LCR has been returned to the learned court below,
oh,
not on record. Because that was a judgment with regard to the statement of the respondent number 2. That's why the service has not been completed. And the registry has wrongly shown it was disposed of. When you pursue the matter before the registry, the matter was not disposed of on merit. That's why my lord, the whole record was held there.
okay. So a judgment was delivered earlier.
Judgment was delivered with regard to manner service of notice upon respondent number 2, whether implement is required or not.
It was not required as per the judgment.
Yes,
Then what happened?
then the service upon respondent number was completed and matter was fixed for hearing. But instead of fixing for hearing, registry shown is dispose of the matter, that's why it was not raised.
Okay. 1 minute. Let me see then. Okay, did the appeal be listed for hearing?
Yes.
Oh, it was shown as a judgment and order, actually. Where is the public prosecutor?
LNB Chaudhary.
Your Lordship, my senior another court. Ask about the
Mr.
matter.
Deuri,
Lordship.
Do you have a copy of the judgment?
My lord,
Now, today is hearing then.
yes, my lord, but original record is not,
Original records are not there.
yes, my lord. It was,
Where is the note?
it's 25-1.
Dealing with a specific raised in an incident was pleased. By to dispense with the requirement, however, this section having failed to comprehend the order in a proper perspective, misconstrued the matter to be disposed of and send back the LCA to the concerned lower court since the aforementioned case was inadvertently sourced or shown and disposed of. When query by an advocate and proceeded, it is found that it is pending. The section regards it as an inherent mistake and yeah. Heard Mr. S.K. Dury, learned counsel for the appellant. And Mr.
D. Sutradhar.
D.
Sutradhar.
Putradhar. Learned counsel representing Mr. NNB Chaudhary,
NNB Sudharan.
learned public prosecutor
Hmm.
for the state of ownership of this. Also. From the office note dated 25/1/2024, comma, it transpires that after a judgment and order dated 27/1/2021, comma, the registry has sent back the trial court records on 4/2/2021. Offices, office. What is a judgment, impugned judgment?
Yung judgment was passed by the learned additional session court.
Eastern Zone Pasighat.
Now,
What is the case number? PSG case number.
yes,
Sessions, okay.
yes,
The office to requisition. Case records of PSG. Sessions case number 29/2014. From the Court of Learned Additional Sessions Judge, comma,
now, my lord, it is session that
okay. Case records of so and so. At least the appeal. After 4 weeks. With the record, with the state case records, and then we should really kill. Mr. Chaudhary, pursuant to that judgment, where
Yes.
that informant, notice to an informant can be dispensed to it
Yes, my lord.
in case of IPC offense.
Yes, my lord.
Office has inadvertently
Yes, my lord.
thought that the appeal was disposed of
Yes, my lord.
and LCR was sent back.
Oh, LCR is necessary. my lord.
Now LCR, we are requisitioning the
Yes,
LCR.
my lord.
So
Now-
that will be after
Yes, my
4
lord.
weeks.
But my lord, I argued that point, my lord.
Yeah.
Now, my lord, that point has been changed, my lord.
That is regarding POXO,
Yes, yeah, Foxo
not
also.
in case of
Yes, my
IPC.
lord.
I think,
That,
I
my
think
lord, yes, my lord. That, my lord, one MLS on that.
some Deepak Nair, perhaps.
Yes, I think. In that case, my lord,
Yes.
that has been recently changed, my lord. Yes, the monolith.
I am trying to keep myself
Yes,
abreast only from yesterday.
Yes, my lord.
One Deepak Nair,
Yes, my lord.
there it is in respect of POXO and 376 AB, etc.
Yes, my lord. For-
There service of notice upon the informant
That's fine.
or a victim would be necessary.
That's fine.
But so far as this judgment has been referred perhaps,
That's fine.
Bormoti Pangen
Borputri Pangi.
was limited to the issue of imprisonment of the victim
That's fine.
so complainant in a case under the general law.
Yes.
The law is not changed.
Yes, sir.
Let it be.
That's fine.
After 4 weeks with the records.
Yes, sir. God bless. My name may be recorded.
On the name of Mr. NNB Chaudhary, learned public prosecutor, Arunachal Pradesh, be reflected in the respondent side like all this.
That's fine.
One.
Second case number 22.
1 minute, Mr. Prasad. Very useful. 9 minutes, good for you. Here. MS Bhai, I have received a new paper book.
Account by sir.
Huh?
Only one.
5/10/2023, there is an order that fresh paper book.
We made.
Because some pages of the paper book in the court record does not match with the contents of the paper book given to the learned additional public prosecutor.
Oh, yeah. Oh, we have
So
received one.
accordingly, registry is directed to furnish a fresh paper book
Lordship, may I
to
know
the
the
learned
date of the
additional public
order?
prosecutor B. Bhuya.
Date of the order?
5/10/2023.
This is 12/10/2023. Lordship, due to some personal difficulty, I'll leave the court at 12 o'clock, my lord. Then if the matter doesn't finish, they'll take over, my.
Yes.
I was appointed as the fiscal inspector.
Hmm.
Later on, they.
Who will do? Huh?
So then, something remains my argument.
Then time will not be apportioned to you equally. Right? Only 90:10. It is not like 50/50 or 60/40. Only 90:10. Yes.
On petition appeal challenging my conviction. The petition case number 22 DU of the 2024. The appeal judgment is dated 21/11/2019.
21/11/2019.
Passed by the additional secretary.
Udalguri.
Completing me for like. The system 302.
Okay.
Economic find of the account. The system 440
448 also. Hmm.
for 1 year. Education. Or for unlawful assembly.
448. 302, 448. That's
And 143, section 143,
143.
house rent.
Hmm. Unlawful assembly. Huh?
143 unlawful.
Where is the judgment? Let us see. Judgment in the paper book.
Conviction is at page 64.
6.
Paragraph 4, page 64.
One. Sixty-four. Okay.
In case in brief,
Where is the FIR?
the fire is at page. Page.
Phase 3.
Phase 3.
The fire was logged by.
Who is this? Budhiram Mardi. Phase 3. Yeah, yes.
7/4/2010.
Can it be a bit louder, Mr. Prasad? Hmm.
My lord, am I audible?
Yes.
Humble submission is that around 12 AM last night, 5 boys of Jangalbari Gaon came to the house of Mangal Hasda of the same village, and they gagged the mouth of my elder sister Renuka Hasda and
Worship's not there.
Not there.
No.
Is there mentions that they are
Yes.
being produced
Yeah.
before the magistrate for recording the statement?
জবান মন্দি রেকর্ড করার কারণে কিন্তু বাট নাথিং ইজ দেয়ার ম্যাডাম
In cross also, she reiterated that I was produced before the magistrate. In chief also.
Right.
Who is Sunil Hemram? He is PW.
Sunil PW4. Lordship, something I have found, page 17. Lordship 164 statement. Swapna has said. And next comment.
Exhibit corner.
Mhm, mhm. Good fun, eh? Good fun. IO is telling a different story altogether. IO
My lord.
is telling a different story. Somebody informed the police station that there was a pit
Yes,
and some
it was
plastic.
exhumed later on. It was exhumed later on.
In the list of exhibits is not there, sketch. Then he says that DD entry was registered.
Hmm.
He initiated an investigation.
Hmm.
Then one pit was found. Then that was dug. Then body was disinterred. And after body was disinterred, it was inquested. Thereafter, this affair came to be lodged.
Oh. Then the earlier GD entry will be treated as an
Where is
FIR.
that?
It's
There
not
is not,
there, my lord. No,
not there.
not there.
See, these things have started happening.
My lord.
Somebody told the police station. Then he went to the spot. Then sweeper came. The pit was dug. Then one dead body was disinterred.
My lord.
Executive magistrate came.
My lord.
Inquest was done.
My lord.
Perhaps thereafter at 3:30, then she was identified as Renuka. Thereafter, this at 3:30,
My lord.
this FIR came to be lodged.
Lordship.
Now he says that I did the first part. He doesn't know whether that GD entry was exhibited or not.
But your lordship,
Where is the inquest? Where is the inquest?
inquest report, page 77.
I used to be elected.
Calgary, Buddhist, Rangalpedi, aborted dead body, exhumed. See, 77, exhumed
Assume.
from the alluvial land by a sweeper. Start holding NPS on the body of the disease identified as Renuka Hasda by Sopon Hasda. Srimati Sopon Hasda means younger
PW6.
PW6. So according to PW6, at one point something is confusing anyway, that 2 came or 5 came, 5 persons, right,
In the
to the house. Niren was there. Midnight Niren was there. Niran Doimari,
Dhirendra Mari was there. Niran.
he was with her elder sister.
The sister in the house.
In 164, she said, well, it's somewhat different. The story was somewhat different. She improved later on, perhaps. They came, they asked for Niren Doimari's bike. Something like that. Then some other things. Then thereafter, they say that they took their elder sister. But here in PW6, first she said that both the accused persons means
2% were
who's to
facing trial.
trial, that is Budhi,
Budhiram Mardi and Madan Mardi.
Budhiram and Madan. They came and asked to open the door. Their voices are known. Elder sister opened the door, took her away.
Both the accused persons took her.
She says, out of fear, I remained inside the house. Now she started saying the accused
Niran was
person.
also
At that point, that is something.
Now, so thereafter she is saying something
They
else.
say the accused persons took me with them also. Then she said this
So the gagging part goes away.
gagging part, then Diwan, Madan Mandal and Lokhiram committed bad act, but that is belied by the medical report. That throws some cloud.
Further, she said in her FIR, 2 persons took her, 3 persons took her elder sister. Here, the third person, Rajkumar, is seen to be in both the places, with her also, with her elder sister also. At page 18, she says that 2 accused persons were joined by some other accused person. Now, these 2 persons were
So
facing trial.
according to you, what kind of case? Because exhumation, she said, exhumed.
Exhumed.
Coming home, I told my father about the occurrence. Father informed this to the villagers. The villagers searched for my sister. Having seen near the blood near the river, they informed police. Okay. Now
That part
it
is
is
connected.
connected. She came back. She informed father. Father told the villagers. Villagers searched for her sister, and having seen blood near the river, they informed the police. Okay, now it is connected. So what will be the case? So far,
What she says in her statement.
otherwise, out of the witnesses, few witnesses are seizure witness,
Seizure witness.
inquest, postmortem,
Nothing else.
IO,
Circle
and
officer.
circle officer,
Who conducted the inquest.
and what remains?
The informant.
PW3, PW4, PW5, PW6. And which is PW7, 8? Those are, they are said nothing.
Nothing under.
I think they said nothing.
Nothing.
Hmm?
PW7
PW7
identified the
and
dead body.
One is the inquest witness. PW7 is an inquest witness.
Inquest witness.
PW8, my lord, he was
Seven,
duty in
6
charge.
is
He
what?
just came to
7
Guwahati
is?
to get this case diary.
7 is
7 is witness to the inquest.
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 Kishore Sirpoli. 7,
7,
inquest.
inquest, my lord.
She identified the dead
I
body.
identified the dead body of Renuka Hasda, the deceased.
Okay, 8,
8
Eight is
is the police officer who came to give the case
Yeah,
diary at
give the case diary only.
Guwahati.
I was
And
inside
give the
the
case
Boy
diary
of
only.
Pundra, of course, I was not involved. I did not conduct the investigation. He is no,
Nothing from his.
this is who performed PW9,
Circle officer.
PW9,
who performed the inquest.
he conducted
Uh,
the inquest, my lord.
So let us
Now-
go back to again
6.
4, 5, 6, 7, 4, 5. 4, 3, 3.
3 men.
Hostile. Hostile. Then PW4 he did not witness the incident.
Hearsay.
Hearsay. He heard everything.
He heard everything.
PW5,
Is the brother.
brother.
Hearsay. Heard from his sister and father.
He was not examined in the course of investigation.
No.
He said about seizure list. And he also heard. Father told him.
Father and the younger sister. PW6.
And okay. Father was not examined.
Father was
Father
not
was
examined.
not
Niren Doimari was never examined. Then we come back to 4, 5. So now everything hinges on PW6.
PW6.
Sir, we will come back after 20 minutes.
Lordship, if your lordship permits, can I do my part tomorrow, my lord?
Is it so?
Hello.
You know, we
I'll
are getting,
conclude it.
Let him,
We'll conclude.
have to,
Yeah.
appointment at 1 o'clock, my lord. Doctor's
okay.
appointment.
You want to go now?
Yes, my lord.
Okay.
She'll be there, they'll be there.
Okay, we'll defer it.
I'll do my part tomorrow. Okay.
Yes.
I lost the case. I know both the accused persons. I presume that these two persons are Madan and Budhiram because they were at the time. This is Renuka. Hasda was my elder sister. The occurrence took place about 4 years ago. The occurrence took place around 12 a.m. Since both the accused persons are my co-villagers, I know them very well. Around 12 a.m., both the accused persons went to our house and banged the door. Both the accused person asked us to open the door. We recognized the voices of both the accused persons. Recognizing the voices, my elder sister opened the door. Both the
7.
Why you have mentioned? Okay, okay. 1 minute, law is covered. But to understand that law is covered, how this pay scale of judicial assistant in Guwahati High Court has been fixed. Page 30. One minute. Page 24. Hmm? Some High Court rules, no? The 13. Guwahati High Court service rules. Schedule. Schedule 1. Registrar General. Class 2A. Library. Class 2B. Class 2C. Class 2C. Where from you have got this? Guwahati High Court rules. Do you have the full set? Because it is not reflecting here. It is, though it is 2022 edition. See here, the library assistant scale, judicial assistant both 14,650. Okay, great pay. Take note it. No? Not keep it. What are the precedents you have said? Just let me have a look. You have annexed? No, you have annexed somewhere. I know yours will be saying similar things, but where is the judgment? One. 1984. Luch. Uh, Mr. Nath, I am asking for the point that there are different sets of rules normally. One is under proviso to Article 309, and second is in respect of High Court service. It is proviso to subsection 2 of section 229. Right. Now, in that rule, that is 1967 rules, these pay scales have been same thereafter changed, and thereafter changed, and as a result, you are placed at a lower grade pay, right? And because of by virtue of the rules, though you are claiming for equal pay for equal work, right? The question is, bigger point is, that is why I asked for that judgment. It is because here your prayer is that mandamus should be issued, directing the respondents to place the pay of the petitioner in the pay scale of 14,000 to 49 with a grade pay of rupees 8,700 from the month of July with arrear monetary benefits since the date of implementation of the Assam Services Revision of Payroll so and so. Now this has been incorporated in the rules as you have mentioned. Page this is you have annexed, right? Page 20 onwards. 2020 onwards. This is the main one. This is Guwahati High Court rules, Guwahati High Court services appointment so and so. It has been incorporated there. Your pay scale as well as the pay scale of judicial assistant. Now seeking a mandamus in respect of the grade pay, different grade pay incorporated in the rules. That is a issue whether this can be handled by the single bench. You have, because the earlier judgment was delivered by division bench. But the question is, the bigger point is, the Supreme Court says if a mandamus is required against the rule, this is also constitutional rules. Constitutional rules, provision 309 rules are also constitutional rules, right? Now, your grade pay and judicial assistance grade pay are incorporated in the 1967 rules, right? To make you equal, that is to be interfered with. Have you got the point? Now, whether single judge, single bench is in a position to interfere with a rule, constitutional rule, framed under the proviso to Article 2 of Article 229. That is the first question I am asking you, because in my prima facie view, I think that is not within the ambit of a single bench. No, to make you equal, you have to bypass the rule. You have to say that this rule and schedule. Have you understood the point? It is, had it been a normal executive order, then yes. But question is that to tweak with the rule, to interfere with the rule, 1967 rules. Have you got it? Now, to make you equal with judicial assistant, you have to refer to the rules, and that is already as a rule, 67 rule, part of the rules. Now, your grade pay is there, 7,000 something. Is it not? Now, you are annexing here. It is what? Basically same. When it happened? Now, when this was incorporated, because this, here it is page 24, it was same. All and okay. When it changed, because in this book, it is 7,600. Huh? when this 7,600 got incorporated in the 1967 rules, Mr. Nath, you are not, here it is already incorporated in this book. No, I am not forwarding any contention. I am asking you the point of fact. This, here it is incorporated in this rule, the book I am having, it is incorporated as 7,600 grade pay for library assistant, and for judicial assistant it is 8,700. When this got incorporated, Mr. When? This does not answer the question. When means when? Please see. I don't know. That is why I am asking you. Please enlighten me. See, the problem is, Mr. Nath, it is incorporated in the rules. Your pleadings may be deficient. I want to be sure before proceeding. See, 7,600 and 8,700. No, top scale, pay scale. Judicial assistant, please read. $7,600, right? It is part of the rule. Now, I don't know whether Mr. H.K. Das has changed it by way of an executive order or by incorporating it in the rules, right? In the first case, no, that is Mr. Nath. I have seen it. Thereafter, I have put the question. By a notification, it has been redesignated as judicial assistant. So don't, I have read it. Thereafter, I am putting the question. Now, see, there are two things. You have to answer me. It cannot be, I cannot assume a jurisdiction which I do not have, right? If it is by an executive order by Mr. H.K. Das that your grade pay has been kept at 7,600 and judicial assistant grade pay is 8,700 fixed. Okay, that is one part. But if by incorporating it in the rules, which is under the proviso to subclause 2 of Article 229, then this court will not have the jurisdiction to issue any mandamus against the rules. Have you got the issue correct now? So what kind of case you have projected here? Because it is in the rules. Can you enlighten the other sides? I cannot say. Humble submission will not do. We need the facts. See, otherwise it is difficult. Because if it is in the rules, Mr. Law is settled, subject to what you argue, that a mandamus cannot be issued against a rule, right? It is, I don't know about 229. At least I know that proviso to Article 309, those are, no, please, Mr. Nath, those are constitutional and legislative in character. At least I know to that extent. I don't know about 229 proviso rules. Right. So, if it is suppose it is incorporated in Assam Services Revision in Pay Rules, that is also proviso to 309 rules. Then single judge, single bench will not have the jurisdiction to correct and make pay parity going against the rules. Have you understood? Have you understood the point? Now, what is the nature and character of a 229 rules provider? If it's in the same pedestal, then a court of single judge may not be able to make your grade pay in parity with a grade pay of judicial assistant by going against the 229 rules. Right. So here, assumption, presumption, I think that will not do. We need that as a matter of fact. Mr. Das, can you highlight? Because your High Court rule say grade pay is for library assistant 7,600. Though page 24 says, oh, it was earlier page. Now, because of the same scenario, whether it is incorporated in your High Court rules, it is already incorporated. So, now, as on date, in the present scenario, when did it happen? It is to be framed by the Chief Justice. But in case of salaries and so, 229 proviso, if it is regarding salary, it has to be with the approval of the governor. Right? Then it becomes rules. So other service conditions, promotion, seniority, all these can be set by the Honorable Chief Justice of the High Court. But when it comes to salaries, it requires approval of the governor. Now here, if it is incorporated after the approval of the governor and it becomes the part of the rule, I don't know that this court sitting in single bench, whether I can issue a mandamus to say that make it equal. What was the controversy before a single judge? So this is a final issue, mister. You cannot say that this is a precedent for all cases to come. Page. One minute. Page 48. So first you need to read para 1. What you are challenging there is a letter of the deputy registrar. No, then it is not maintainable then. Since it is incorporated in the rules, then it is very easy for me. Those judgments will not do, mister. But if you are not challenging this, it will fall, it will fail. Then, okay, you want, it will be easier for me. And that I don't know. I am not here to advise you. When Mr. Das, it has been changed. Because it is a part of the book now. Now, whether I don't know how it has got incorporated. That is the difficulty. If it is part of the rules, by way of the natural situation, as per the procedure 229, then it becomes part of the rule. Then this court will not have the jurisdiction, perhaps, to issue a mandamus, right? Or otherwise, suppose like the one by an executive order, somebody raised their hand, said, okay, stop, let them be at 7,600. Then this Nath's contention that equal pay, historical parity, all these will have force. But it has been changed by a rule, then this court will not have. Have you got the point? No, but if it becomes 229 rules, it becomes constitutional rules. In a proper manner. If suppose if Mr. Poridi has on its own has incorporated is one thing. Right. But if it is as per procedure, then it becomes constitutional rules. In such situation, this court will be handicapped to issue mandamus. That is the point. I do not want my judgment to be set aside on that point. I don't know also. At that point of time, you are equal, right? Then suddenly, suppose our Registrar General has changed your pay scale. Yes, then we can say because of the earlier division bench judgment, holding that both are equal. So they should be given same pay scale. Yes, it would be easier. Then that is the difference. There is a basic point. Mr. Das, have you got the point? Then the question of jurisdiction of this court is in issue. I will not assume a jurisdiction which is not vested in me, Mr. I am more careful than you. At one stroke of a pen, it will be. Go. You got the point. He should have gone through. He should have gone through. Huh? Again, right, but there is no direct authority. That is my primary view, but I am not 100%. I am not reached the 100%. I am at 95%. I want to be 100%. With my limited knowledge, I have found that it is almost 95%. I am of the view that it is akin to proviso to 309 rules. And if it is otherwise, if rules under proviso to 309, it is, though it is framed by the executive, but it is constitutional and legislative in character. And in that case, a court sitting in single bench may not be in a position to issue amendamus that make the two post equivalent, give same pay to the post. This will be within the province of the division bench then. It is, this is a difficulty, Mr. Have you understood? Because you are pursuing the matter for last 6 years. I have not heard. It would have been easier then. I think I could have raised it in the last point, right, Mr. Das? And thereafter, I mean, not maintainable. You get the background from the registry and also the thing that if it is akin to a proviso to 309, then if it is on the basis of that, we can say that it should be placed before on the administrative side of the Chief Justice, right? Otherwise, you will be failure. If you go on arguing, we can decide. That is a difficulty. And you have not amended the writ petition. What? But it is part of the rules. Because earlier 2-3 occasions it was there because it never occurred in my mind. I did not hear you because it was only adjournment and adjournment. Either you or Mr. Da or Mr. Borpujari. Many a times Mr. Borpujari. What to do? Take your call after 3-4 weeks because this code will not be available in April only. Heard Mr. S. Nath Learned Counsel for the petitioner. Mr. R. Bopuzari, you are for? Okay, Mr. H.K. Das, learned standing counsel G20 High Court for reference number 1, 4, 5. And Mr. R. Bopuzari, learned standing counsel. Okay, who is there for state? Nobody. They are also one of the main party. They are the vital cog. High Court will forward that please make this pay scale and get it approved from the governor. Governor approves it, then it becomes part of the. Inform them. Can I record? Okay, Mr. R. Bhurpuri, and standing up to Finance Department for point number 3. None has appeared, huh? Okay. Mr. D. Nath, Senior Government Advocate Assam for point number 2. The petitioners at the time of filing the petition were serving as library assistant. Both library assistant at that point of time. Where from you are saying? In the body. I read the body. Where? Okay. Okay. The petition number 1 is assistant librarian. And petition number 2 is library assistant, whose conditions of service are regulated by the Guwahati High Court service. Yes, it's 636. Service rules. 1967. Framed in exercise of the powers conferred by Article 229 of the Constitution of India. Also, the petitioners have, by preparing the instant writ petition, the petitioners have sought pay parity with the post of judicial assistant. Post of judicial assistant, which is also part of the said rules. Post of petitioners according to petitioner, though the post of judicial assistant and the library assistant are in the same pay band, the judicial assistant is granted a grade pay of rupees 8,700, whereas a library assistant is granted a grade pay of rupees 7,600. According to petitioners, the post of judicial assistant and library assistant were enjoying the same pay scale prior to 2017. It has been brought to the notice of the court that in the schedule to the 1967 rules, though both the post of judicial assistant and library assistant are in the same payment, comma, the grade pay in respect of seat 2 post are at variance, as a judicial assistant is eligible for a grade pay of rupees 8,700 and a library assistant is eligible for a grade pay of rupees 7,600. So, Mr. Das, standing counsel CAC has submitted that he will make endeavor to obtain instruction as regards the procedure followed for incorporation of different grade pay in the 1967. That will complete everything. Procedure means time, place, how, everything. Whether single judge will move ahead or a division bench. Release the case after 4 weeks on a date to be fixed by the office. Later. I don't know. I know about this, but I don't know about the future. No. In the a month of April, after 4 weeks, on a date to be fixed by the office. But you have made the exercise for last 6 years. Perhaps prima facie in futility before a single judge. My view, subject to correction.
Item 2. Item number 2.
That day you were referring to something, right? Sir? Das. Yes, 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 you are saying something on that day. What will be the discretion available for the selection committee? Any minute? This is the minute only. Because in the list of that availability of ACR, right? Yes, so Paul's 3 ACRs were available. Respondent number 5 or 6, only 2 ACRs were available. But here, if I remember correctly, that ACR which is having average, No. You of your pleadings. You of your pleadings, because when the order promotion was passed, it was passed on 29/11/2021. Now, you have provided him with a ACR only on 6 December 2021. One by one. Let us get the facts right. We cannot at the same moment every facts, 10 facts we can 6 December 2021. That this ACR by no means can be considered because it was on 6 December. You took the decision to promote him 29th, 7 days earlier. So this is redundant. They could not have taken because it has a, even it is excellent also, it should have been prior to order of promotion. Then it is one another thing that you did not, you have decided to expunge something, but grading you decided to keep as average. That is another thing, but everything happened subsequent, prior to passing of the order of promotion, subsequent to. So in that situation, this 2020 ACR could not have been taken by the selection board. I'm seeing everything, not from just don't feel that. Now the question is, on what basis? Because there are many criteria, merit comes suitability, seniority comes merit with suitability, everything was there. Suitability was not a part of the. Now in such situation, suitability, it was there criteria. In many service rules, merit comes seniority with due regard to suitability. Seniority comes merit with due regard to suitability. Those are there. Now here it is simply merit comes seniority. Now question is, seniority comes merit. Sorry, seniority comes merit. Minimum benchmark for merit, then seniority will have precedence. Now, where from you have assessed this all this merit? Minimum benchmark. What was the penalty imposed in a criminal case? That day, obliteration. One. One is not a penalty. Mhm. Okay, let us see paragraph 29. What is his provision of good conduct order? Yes, Mr. Das. 70. Order. Hmm. 310 2000. It is your affidavit, right? Internal page 50. Okay, what is the operative part? $1,000 or simple imprisonment in default 1 month. So what happened in appeal? Probation of offender. Huh? And see here. That is already there, I think. You have given, it is part of record and detail, not a video. What is your what is your bond? Any idea about the bond? The bond he is released on probation of good conduct on execution of a bond. If you come to page 36 of your pay, right? And if you read section 360, he can only be released on provision of good conduct on execution of a bond, right? So, and that could be for a particular period. If you exhibit good conduct for this period, you need not have to pay the fine. But you exhibited bad conduct during that period, then you have to pay the fine. Now, what is the period of the bond? See, because everything is, what can I say, the maintenance of record by Mr. Das is not very up to the mark. We have to go to the legality now. Any idea? See, then it is up to 3 years. The bond is to be executed for 3 years. Meaning thereby, you are running the sentence on hardly on executing a bond. But sword is hanging over your head. The moment you commit any other thing, court will. So you are on trial for a period of what period? That could be taken into consideration, Mr. Das. See, probation of good conduct is up to maximum 3 years. When I examined this order of the appellate court, that was passed on 35/2019. If you add 3 years, it goes to 35/2022. And the promotion order was prior to 3 years. Right? So that sword was hanging over you. Sentence has just been changed to release on probation of good conduct. But till 35/2022, you have to exhibit good conduct. Now, Mr. Das is saying, you were warned also. You were warned on what basis? Same criminal case. So 3 years, any idea about the bond? Any idea about the bond? Then difficult. Yes, what? Any more submit? Because this conviction is there. The sentence part you have converted into probation of good conduct. That period might have been running. You are not out of the blue. So I tried from this way, that way, but you are there is hardly any ground because in the meantime you have retired. But this fact is apparent that your conviction and your sentence of fine by the trial court is there, then your appeals dismissal on merit is there, then your release on good conduct, that is there. So that is why I have asked whether what is the period of the bond. Because I think period of the bond is, if 3 years is running, then he is still on, you are still on that conviction and the ripple effect of conviction. Then the authority may not find you suitable. No. This 3 years period is not yet over. So we do not want a person who is on probation of good conduct, executing a bond to promote. When did you retire? Huh? No, when? 20. Otherwise, no. Kalir, Kalir, কালি এটা ডিক্টেশ্যন কৰি দিছিলো যে প্ৰভিজন তাতেই এইটো ফেলো লগত প্ৰভিজন অফ গুড কণ্টাক্ট বুজি পাইছো ভিতৰত আছে এই ৰেকৰ্ড আছে এই ৰেকৰ্ড কেছ নম্বৰটো কিবা এটা আছে এই মোৰ টেবুলত আছে টেবুলত লাগে আছে ৰেকৰ্ড Mr. Sharma, you gave something yesterday or day before yesterday? Probation of good conduct. Let me find out. It is there already. Because as Mr. Das has pointed out, para 29, Janaki Raman, to qualify for promotion, the least that is expected of an employee is to have an unblemished record. That factor may play a role. It is not that their maintenance of record is failure officers to maintain this score. Just because of his conviction and that his record is, this has shown a not a positive picture about him. John Sushil Kumar. Another one. Bakshi Ram. Did it touch upon anything about promotion also? Non-obliteration. What about the provision of Offenders Act? Which paragraph you are reading? Which paragraph you are reading? Or which one? Bakshi Ram. No, but, let us read paragraph 8. There it is, that paragraph 8. See that would clearly show that the control of the offender is retained by the criminal court, and where it is satisfied that the condition of the bond have been broken by the offender who has been released on probation, the court can sentence the offender for the original offense. So this clearly shows that the factum of guilt on the criminal charge is not swept away. And the stigma continues. So effect continues. That is why I don't know whether for 3 years or not, but if the effect continues, I think his promotion, not giving promotion is proper. Right. So if we add 3 years to the order of the appellate court, then it goes to 22. And prior to that, he was not given promotion. That is the difficulty. Okay. That was not Mr. Charles's application of mind. Yes. Janaki Raman. Yes, his stigma was continuing at that point of time. That is a difficult. This much you have. Mr. Mohanto, anything? Basically, it is not a case of dishonesty. It is a case of injuring your colleague. That is not dishonesty. Is it? That has been expunged. Is Mr. Tiwari? Yes, you are waiting. I don't think I'll be dictating now. But I'll go beyond. Because I am sitting also in a division bench. And thereafter, I'll be, it will be in April only. Then better to wait and we'll record that only. No, we'll April. We'll just record his submission. Okay. Mr. T, please take your seat. Let me go through. No, no, I'm not closing it. I think it is there. Entire matter has been placed before the staff committee. So let it remain in a month. Okay. Heard Mr. P.K. Tiwari, Lion Senior Counsel for the petition, and Mr. H.K. Das, Lion Standing Counsel. GHC. So Mr. Das, Lion Standing Counsel GSC has submitted, instruction, and the representation of the petitioner has been placed before the concerned committee for consideration. In such view of the matter, he has sought for listing of the case after 4 weeks. So as agreed to by the learned counsel for the parties, list the case on 9th. Where you pray? Okay, let us start. Yes, Mr. Das, anything to add? Huh? Whatever, now we are in a read court. We are in a read court now. Whatever may be, but considering that you were convicted, then your appeal was dismissed on merit, then you were released on bond, that your conviction is not there. It is only the sentence part which has been modified to probation of good conduct. Now, normally it is 3 years. We don't know about the one, but otherwise report and Janakiraman's observation that one should be having unblemished record. That does not appear to be so. So why just for the, otherwise they have said you are found not suitable. May not be in clear terms, that this, that, but at least they have found your case was considered. Your case was considered, but you have not been found suitable. Now, whether certiorari jurisdiction, now by certiorari jurisdiction, we should exercise that it is so manifestly bad that it requires interference. We are in a limited jurisdiction. Even then, it is not considered, or let us assume everything. But by going by your conviction, and also Janaki Raman, this is not, which is something shockingly affects the conscience of the court. Let me place the facts. Okay, give me. Please take your seat, Mr. Cross. In the present petition instituted under Article 226 of the Constitution of India, the petitioner has assailed an order bearing number 183, issued under memo number page 16, dated 29/11/2022, issued by the no, by the 21, by the issued by the respondent number 3, whereby the respondent number 6 has been promoted to the post of civil Dar in the office of the civil judge, Kokrajhar, with effect from 1/12/2021. Full stop. Where the relevant and necessary facts for the purpose of consideration of the challenge made hearing can be exposited, briefly, as follows. whether he was senior or ha. No, some was there. Uh, Mr. Das, you have given me a chart. Is it not? There also, response number 6 was senior. No. This one is your chart. I have never prepared. One minute. I'll go into 1 minute. This is your chart. Or who has given this chart? Who has given this? I am not prepared. Oh, you have given. Okay. Okay. Let me proceed then. Where is your order? Hmm? In your affidavit of which? Your affidavit of position is okay, 36 to 45. 36 to 45. Paragraph. But that order is not annexed anywhere. Uh, in your case or what? Case of Paul. Paid for appointment as petition was not considered for on the ground that there was some offense there is involved. Well, according to the no, what is this? What does it have any effect? Tell me. 1 minute. No, Mr. Mohanto, by page 121 order, everything has been corrected. You have submitted it partially. That is not a correct reflection of. No, it is all, it is an order. Page 121, order of learned session judge. This is 18 September 2014. Now he is asked to correct the seniority of C. Paul in the gradation list of grade 3 of this establishment with retrospective effect from 27/7/2000. You have not challenged the order. No, you have not challenged the order that he should be given correct position in the seniority list with retrospective effect from 27/7/2000. You have not challenged the order. Mister, it is gradation list. This is also not correct reflection of facts. This is also not correct reflection. Here your UDA is 18/9/2007. 4. Paul. That has been corrected already. How much I will go on recording? Wrong facts. Already galore. Mistakes galore. No, whatever, Mr. Mohanto, it is in existence since 2004. We are into 20 years. His position is corrected on the seniority list. So stop the petitioner. Was initially appointed as a lower division assistant in the establishment of which rule, Mr. In the establishment of session judge, district judge. Oh, his original appointment order is not available. In the post of lower division assistant LDA. And in the establishment of the respondent number, in the establishment of the district and session judge, Kokrajhar. And he joined his service on 23/5/2019. Full stop. Thereafter, he was promoted to the post of Upper Division Assistant. By an office order dated 25/8/2004. Full stop. As the petitioner was placed second, no, like as the petitioner joined late in the post of lower division assistant, then few other appointees. His position in the gradation list were lower, right? Uh, uh, Technically, being cool. It is relevant. It is pertinent to mention that the selection process was undertaken in the year 1990 and pursuant to completion of the selection process, on completion of the selection process, a select list was prepared and published on 20/04/1990. So stop. In the said select list, the name of the petitioner appeared as serial number 2. Full stop. By an order dated 23/4/1990, the others selected persons from the said few other selected candidates from the said select list were appointed as lower division assistant, but the case of the petitioner was not considered for appointment on the ground that there were some objections raised regarding the involvement of the petitioner in a criminal case. Full stop. On preparing a repetition, civil rule number 859/1990, the petitioner was, the respondent number 5 was directed by judgment and order dated 16/5/1990 rendered in the said writ petition to give appointment to the petitioner. And the same was accordingly done on 23/5/1990. Full stop. In the inter se seniority list provisionally circulated, inter se seniority list of incumbents provisionally circulated by the establishment, the petitioner was shown junior to the other appointees who were appointed pursuant to the order dated 23/4/1990. Full stop. In a writ petition, in a judgment and order rendered in a writ petition, WBC number 1959/2000. Order dated 21/5/2003. Rendered in a writ petition, WBC number 1959/2000. It was directed inter alia that the petitioner was entitled to be appointed at least from the date on which the other selected candidates were appointed. And the petitioner would be senior to the other appointed candidates in view of his higher merit position. Full stop. Remedial measures were accordingly directed. Full stop. Pursuant to the judgment and order dated 21/5/2003, the respondent number 3 passed an order on 25/8/2003 by placing the petitioner above four other appointees who were appointed on 23/4/1990 and granted all consequential benefit full stop. Another order was passed on 18/9/2004 by the respondent number 3. Oh, I got it. By an office order dated 25/8/2004, the petitioner was promoted to the post of Upper Division Assistant in the establishment of the respond number 3. Full stop. By an order dated by an office order number 32 dated 18/9/2004, the respond number 3 had ordered correction in the seniority position of the petitioner in the gradation list of the establishment. And as per the said order, the petitioner's promotion was given retrospective effect from 27/7/2000, right? Para. When the petitioner uh, where is the order of promotion? Page 16. When there arose a vacancy in the post of civil solicitor in the office of the civil judge, Kokrajhar, the respondent number 3 constituted a selection board. Consider a selection board for the purpose of considering the incumbents in the feeder cadre of upper division assistant for promotion to the said vacant post of civil solicitor. Full stop. The selection committee board held its meeting on 26/11/2021. And after such selection, in the said selection, in the meeting of the selection board held on 26/11/2021, the selection board recommended the name of the respondent number 6 for promotion to the post of civil solicitor in the office of the civil judge, Kokrajhar. Full stop. Subsequent thereto, the impugn order has been passed, whereby the respondent number 6 has been promoted to the post of civil solicitor in the office of the civil judge, Kokrajhar. Respondent number 5. Respondent number 5, sorry. Respondent number 6 or 5, so 5. The petitioner was one of the incumbents in the federal cadre whose case was considered along with others. How many? Along with 2 others, including the respondent number 5. Full stop. Agreed by and dissatisfied with the order, impugn order dated 29/11/2021, the petitioner has preferred the instant petition challenging the order of promotion made in favor of the respondent number 5. Para. I heard Mr. P.K. Das, learned counsel for the petitioner. Mr. H.K. Das, learned standing counsel GHC for respondent number 1, 2, 3, 4. And Mr. P. Mohanto, learned counsel for the respondent number 5. Full stop. The petitioner has projected that the petitioner was on earn leave for a period of 14 days from 17/11/2021 to 30/11/2021. Full stop. When after the leave period, the petitioner joined his service, the petitioner was informed that by the impugn order dated 29/11/2021, the respondent number 6, who is allegedly his junior, in the gradation list, was promoted as civil solicitor in the office of the civil judge, Kokrajhar, by the respondent number 2. Full stop. Agreed by the state order of promotion, the petitioner stated to have submitted a representation before the respondent number 2 on 29/11/2021. Full stop. It was only thereafter, the petitioner was provided with a copy of the ACR, Annual Confidential Report, for the year 2020, wherein the petitioner was graded, was given an average grade. Full stop. aggrieved by the average grade given in the ACR for the year 2020. The petitioner submitted another representation on 8/12/2021 before the respondent number 2. So it is the contention of the petitioner that uh, uh, neither the selection board gave any intimation or notice with regard to the matter of promotion or appearance of the candidates before the selection board, nor any interview process was held. It is the contention of the petitioner that as per Rule 6(3) of the Assam District and Sessions Judges Establishment within bracket Ministerial bracket close Service Rules 1987, comma, the basis of the criteria for promotion from the post of UDA to the post of civil solicitor is seniority cum merit. Criteria de Viriano. Which page? এইটাতে নহয় ৰেজিষ্টাৰ অফ চিভিল জাজ হা আৰু এটা লিখি ল'ব লগতে It's an assistance issue. Huh? The petitioner has contended that the criteria of seniority cum merit was not followed while giving promotion to the respondent of 5 and while depriving the petitioner from the promotion from being promoted despite the petitioner being senior to the respondent number 5 in service. Fair. Yes, anything more? The respondents have contested the case of the petitioner by filing individual counter affidavits. Full stop. The respondent of 5 in the counter affidavit has contended that the selection board considered the cases of 3 upper division assistants, including the petitioner and the respondent of 5. And it was after consideration of all the relevant records, including the ACS of the previous years, the selection board recommended the name of the respondent number 5 for promotion in its meeting held on 26/11/2021. Full stop. It has been contended that though the ACR of the petitioner was, though the copy of the ACR of the petitioner for the year 2020 was furnished to the petitioner on 6/12/2021. Containing an adverse remark regarding his dishonesty, comma, the with grading as average, comma, though at a later point of time, the remark regarding dishonesty was expunged, the grading remained average. Para. It has been urged on behalf of the official respondent that the petitioner was had faced a criminal trial in connection with a crime case, Kokrajhar Police Station case number 558/2017, registered for the offences under sections 341, 325, 294, Indian Penal Code. Full stop. The charge against the petitioner was causing hurt or grievous hurt, IPC. Causing grievous hurt to an employee of the same establishment Full stop. The fellow employee submitted a complaint in that connection and before the respondent number 2, when the said complaint stood forwarded to the officer in charge, Kokrajhar police station, the case was investigated into and after completion of investigation, the IO investigating officer of the case submitted a charge sheet against the petitioner, finding a prima facie case for offences under sections 341, 323, 294 IPC. In the trial of ZR case number 896 2017, arising out of Kokrajhar police station case number 558 2017, the learned trial court of additional Chief Judicial Magistrate Kokrajhar, after trial, found the petitioner guilty of the charge under section 323 IPC. So by a judgment and order dated 3/10/2018, passed in ZR case number 896 2017, the learned trial court convicted the petitioner under section 323 IPC and sentenced him to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for 1 month. When a matter was taken for appeal by the petitioner before the session judge, Kokrajhar, the criminal appeal was dismissed on contest. However, a slight modification in the sentence part was made by releasing the petitioner as appellant, that is the appellant therein, on probation under section 360, Code of Criminal Procedure 1973, Code CRPC, after admonition. After his conviction for a criminal charge, the disciplinary authority, by the respondent number 2, as the disciplinary authority, in the departmental proceeding initiated on the basis of the conviction of the petitioner, past tense, or sorry, this dispose of the departmental proceeding without any sort of penalty inflicted upon the petitioner. Full stop. In the final order passed in the departmental proceeding number 01/2019, the disciplinary authority had, however, given caution to the petitioner to avoid himself from repeating similar kind of incident in future during his service career. By drawing attention to such events, previous events, it has been urged on behalf of the official respondents that when the selection board consider the matter of promotion from the to the post of civil solicitor on 26/11/2021, the selection board, after due consideration of the cases and of all the persons in the zone of consideration and the materials on record, had found the petitioner not suitable for promotion to the post of civil solicitor. Post of the selection board, finding the respondent of 5 eligible, promoted him by the imperial order dated 9/11/2021. I have given due consideration to the submissions of the parties, and I have also perused the materials brought on record by the parties to their meetings. Para. The Assam District and Session Judges Establishment Ministerial Service Rules 1987, carried after required bills 1987 or the rules 19. Framed in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India. Regulate and govern the matters of recruitment and conditions of service of persons appointed to the Assam District and Sessions Judge Establishment within bracket Ministerial Service. As per Section 2F 21, quote unquote, appointing authority. Rule 2(3). Rule 2(5). And Rule 2(10). service means the Assam district and section judges establishment itself. Next para. The categories of post in the Assam district and section judge ministerial service cadre are found in Rule 3 of the 1987 rules. Rule 3 has provided a vendor. The post of Seristadar of assistant district and session judge the promotion to the post of Seristadar of assistant district and session judge is governed by the provisions of Rule 3, Sub Rule 3 of Rule 6 of the 1987 rules. Sub Rule 3 of Rule 6 has inter alia prescribed that the post of Seristadar of assistant district and session judge is to be filled up by promotion from amongst the upper division assistant UDS of the district and session judges establishment ministerial concerned on the basis of seniority cum merit who have rendered not less than 7 years of service in the district and session judges establishment within bracket ministerial concern, out of which at least 3 years shall be of continuous service as upper division assistant on the first day of the year in which the promotion is made. The note appended to Sub Rule 3 of Rule 6 has provided that for the purpose of promotion of the upper division assistant, the district and session judge shall prepare a select list at the beginning of each year, taking into account the number of vacancies likely to occur during the year in question. The district and session judge shall associate the additional district and session judge, assistant district and session judge, and munsif in the selection process. The criteria for selection shall be on the basis of seniority cum merit, and the select list shall remain valid for 1 year from the date of recommendation of the selection. Any gradation list, approved gradation list on record? Here? Who before whom, who after whom, it is not there. Sixteen 11. Yes, anybody has that? Where from you are reading that? Page 47. Petition, page 12. This is sanctions. this is not gradation list basically. Because see, the date of appointment, date of promotion, those are not there. It cannot be gradation list. Para 2 point RC. Your affidavit. Okay. This was sometime in January 2019. R1 date is to 19. Running page 14. Last two pages. Let us have a look at page 14. Because rule 9 has provided a paragraph 7. Paragraph 7. No, like that. It transfers from a minute from minutes of a meeting of the selection board held on 22/01/2019, the selection board considered the matter of promotion to the post of Seristadar in the office of the civil judge and assistant session judge Kokrajhar. But the matter was deferred. You are serving as Seristadar. Mr. Das, regular. So matter of regularization. The matter of last time, last two word. Matter of promotion stroke regularization. Matter of promotion to the post of regulation allied. Deferred by taking into account that the petitioner who was holding charge for the said post was served with a show cause notice in view of his conviction in GR case number 896/2017 by a judgment and order dated 3/10/2018. Full stop. The selection board had decided to consider the matter of filling up. Now, like, full stop, para. It is pertinent to mention that by the judgment and order dated 3/10/2018, passed in ZR case number 896/2017, the learned trial court of additional chief judicial magistrate, Kokrajhar, after trial, found the petitioner guilty of the charge under section 323, IPC. The petitioner was therefore convicted under section, or the offense under section 323 IPC, and was sentenced to pay a fine of rupees 1,000 in default of payment of fine, to undergo simple imprisonment for 1 month. Though charges were also framed under sections, for offenses under section 341 and section 294 IPC. The petitioner was acquitted of those charges. The learned trial court was, however, not inclined to give the petitioner the benefit of probation, as because he was a service holder and an employee of the judicial department who was found to have acted in haste and in the most irresponsive way to use physical force upon his colleague. Full stop. The petitioner had thereafter preferred an appeal under section 374 within bracket 3 CRPC, and the said appeal was registered and numbered as criminal appeal number 18/2018. Full stop. The appellate court of learned Session Judge Kokrajhar decided the appeal finding no illegality in the judgment and order rendered by the learned trial court. The criminal appeal was dismissed on contest, thereby upholding the judgment and order of conviction and sentence passed by the learned trial court in ZR case number 896/2017. The learned trial court had, however, observed, by taking into consideration the circumstances and other aspects of the matter under which the offense was found to have been committed by the petitioner, that the sentence imposed on the petitioner was not justified and the case was a fit one to allow the petitioner to be released on probation under section 360, CRPC after admonition. So accordingly, trial court made a slight modification in the sentence part, and the petitioner was thereby released on probation under section 360, CRPC after admonition. Full stop. The it was so a department, it is also pertinent to mention that a departmental proceeding, being departmental proceeding number 01/2019, was drawn up immediately after the conviction of a petitioner in GR case number 896/2017. So after dismissal of the criminal appeal, criminal appeal number 18/2018 on 35/2019, the disciplinary authority proceeded with the departmental proceeding, decided to proceed with the departmental proceeding. So in the departmental proceeding, 2 charges were framed against the petitioner, finding his involvement in the commission of the offense. Committed upon his petitioner's office colleague as acts in contravention of the acts of misconduct under the Assam Services Discipline and Appeal Rules 1964. In the course of the disciplinary proceeding, department proceeding, 4 witnesses were examined before the inquiry officer, who in turn submitted an inquiry report giving his opinion in respect of both the charges. So as per the inquiry report, the charge number 1 was not established on the principles of preponderance of probabilities, whereas the charge number 2 না লাগে এটা। So by taking into consideration the findings recorded in an inquiry report, the disciplinary authority had observed that the acts of the petitioner as acts of the petitioner, an employee of the judicial establishment, the behavior of the petitioner. An employee of the judicial establishment was such kind of behavior of the petition from the petitioner, an employee of the judicial department, was not expected, and the petitioner was cautioned to avoid himself from repeating such kind of incident in future during his service career. The department proceeding was disposed of thus without, however, imposing any penalty upon the petitioner, but with a caution, as mentioned above. It is not clear from the proceedings of the meeting of the selection board whether the what materials were considered by the selection board for the purpose of affecting the promotion. It is not clear, no? From the note sheet of the selection, from the proceeding of the selection board meeting, it is found that they had considered the cases of 3 persons, that is the petitioner, the respondent number 5, and 1 Mr. Kunja Bihari Roy, all of whom were serving as UDS at the relevant point of time. Correct? The selection board stated to have considered the ACS and the seniority of the candidates and the selection board in its proceedings had observed that they had found that though the petitioner was the senior most, 3 or 2,3 or 2. Senior most among the candidates, but considering his ACS, he was not found suitable to promote for being he was not found suitable to be promoted to the post of civil solicitor in the civil judge assistant station judge. The proceedings further observed that The respondent number 6 was the next senior person 5 in the cadre of UDA, and he and the selection board unanimously selected him for promotion to the post of civil registrar in the Swens post of Para. The said order of promotion has been assailed in the instant case. Full stop. The materials based on record by the official respondents go to indicate that the entire records of ACS of the previous 5 years preceding the date of the selection board meeting dated 26/11/2021 were not available before the selection board. Full stop. If for some years the ACS were available for the petitioner, ACS were not available in respect of petitioner. The ACS were also not available in respect of few other years in respect of the respondent number 5, right? I have to record that I cannot go, it cannot. So from such materials, it transpires that the records of the services of the incumbents in the cadre of UDA, in the establishment of the respondent number 3 were not properly maintained. And as such, it is difficult for this court to arrive at a definite opinion as regards the consideration on the matter of promotion entirely on the basis of properly maintained records. Full stop. Mr. One of the contentions advanced on behalf of the official respondents is that the fact of release of the petitioner on probation of good conduct under Section 360 CRPC did not obliterate the conviction, order of conviction passed by the alternate trial court. To appreciate such contention, it is apposite to refer to the provisions contained in Section 4 of the Provision of Offenders Act. Oh, he is 360, right? Provisions of Section 360 of the CRPC. As per provisions of subsection 1 of Section 360. as per subsection 1 of section 360 CRPC, comma, when to reply লিখি দিব। From the said provisions contained in section 360 within bracket 1, comma, no, আৰু এটা লিখিব। Subsection 4 of section 360 has provided that an order to release on probation of good conduct can also be made by any appellate court. Full stop. Does comma from the provisions contained in section 361 and 364. It is evident that the court can release a person on probation of good conduct instead of sentencing him at once to any punishment, comma, only it is found expedient by the court that too, comma, after having regard to the age, comma, character or antecedent of the offender. Full stop. What is that? I read the judgment. Boxy, para 8. Hmm? Katane? Boxy. Sip. Class name of people that এইখিনিতে আছে নেকি চাওকচোন। পঢ়ি আছিলো অলপ আগতে। এইখিনিতে আছে। পঢ়ি যাওঁ দেই, পঢ়ি যাওঁ, নহ'লে পিছত পেছ নহ'ব। If I rise and there are other works, meetings and all, I'll not be able to finish. If I don't. Better. এই বক্সিসমূহ মই ৰঙা দিছো হা। An order release on probation comes into existence so and so, so and so. ৰঙাটো ৰঙা, reference দিব within bracket. Divisional Personnel Officer Sergeant Railway versus E.R. Chelappan, comma, reported in 1976, 3 SCC 190 sequel of And it is settled that a trial court or an appellate court, while invoking the provisions relating to release on probation on good conduct, does not deal with the conviction, as it only deals with the sentence which the offender has to undergo. So, in a case of release on probation of good conduct, the court, instead of sentencing the offender, releases him on probation of good conduct. So, as a result, the conviction remains untouched and the stigma of conviction is not obliterated. Para. Ramasi is which one? Which part? Oh, Janaki Raman. To stop, a person is an offender is released. 1 minute. Okay. An offender, sorry. Line to 8, দুটা কি কৈছিল? An offender, এইটোৱে কৈছে ন? An offender is released on probation with the condition that if the condition of the bond is broken by the officer or offender at during the period of probation, the court can sentence the offender for the original offense. The petitioner in the case in hand, has not been able to point out for what period the petitioner had executed the bond for his release on good conduct pursuant to the order dated 35/2019 passed by the learned appellate court. Absolutely. For the purpose of promotion to the post of civil solicitor in the court of so and so, from the post of UDA, the criteria is seniority cum merit as per the 1987 rules. But for considering a case considering a case of a candidate within the zone of consideration, this selection board And who says appointing authority? Appointing authority has a discretion to consider the fact as to whether such a candidate is considering his antecedents and stroke or past records, etc., would be suitable to discharge the duties and responsibilities of the higher post. Full stop. এই সেইটাতে অফিসিয়াল রেসপন্ডেন্স আছে মিস্টার দাস has sending also GAC has referred to the decisions of the Honorable Supreme Court of India in Union of India and others versus KV Janki Raman and others reported in 1991 4 SCC 109 and Dixit reported in wherein the decision in KV Janaki Raman Supra has been referred to. Full stop. এখানে আগতেই পারমিশন It has been observed in KV Janaki Raman Supra to the fact that an employee cannot be rewarded by promotion as a matter of course. As an employee has no right to promotion. Full stop. An employee only has a right to be considered for promotion, and promotion to a post depends upon several circumstances. Full stop. It has observed, it has gone on to observe as follows kori bracket to bracket etu to qualify for promotion. The least that is expected of an employee is to have an unblemished record. After referring to KV Janaki Raman, the Honorable Supreme Court in Ram Asis Dixit Supra has also observed that the appellant therein did not have any right to be promoted automatically on completion of minimum length of service, as he had to be declared suitable for promotion on the criteria applicable. Full stop. The appellant therein was all along facing departmental proceedings while his case for promotion, along with other eligible candidates in his category, was being considered for promotion in the consecutive years. The criteria for promotion therein was seniority cum merit. The Honorable Supreme Court has observed that since the appellant therein was punished for misconduct, the same would form a part of his record of service, which should be taken into consideration while adjusting his suitability on the criteria of seniority cum merit. If on such assessment of his record of service, the appellant was not promoted, it cannot be said to be by way of punishment. Full stop. It would be a non-promotion on the account of the appellant not reaching a suitable standard to be promoted on the basis of the criteria. Full stop. Finding no merit in the civil appeal, the Honorable Supreme Court dismissed the civil appeal in Ram Asis Dixit Supra. Full stop. Reverting back to the facts of the case in hand, it is established from the materials on record, the stigma of conviction pursuant to the order dated, pursuant to the judgment and order dated 3/8/2018 of the Learned Trial Court, and the judgment and order dated 35/2019. 35/2019, 35/2019 had remained, and the petitioner was released by the Learned Appellate Court after dismissal of the appeal, only on probation of good conduct under section 360 CRPC, that too, on admission. Full stop. Such release of the petition on good conduct required execution of a bond with the undertaking that the petitioner would remain, would exhibit good conduct during the period of the bond. Full stop. It was only after expiry of the period, the court can, no, if it is during, if during the the period, if the petitioner would have conducted any act in violation of the bond, his sentence would revive. Full stop. In any view of the matter, the effect of the conviction would remain for the period for which the petitioner was released on probation of good conduct on execution of a bond. Full stop. The factor the fact of conviction of the petitioner is one which cannot be ignored and which must be taken, which must have to be taken into consideration by the selection board as well as by the appointing authority when the question comes for promoting the such an incumbent to a higher post to discharge higher duties and responsibilities in the establishment post of. Yes, but the decision you have relied. No, that you have such your right. There are 15. The power of judicial review under Article 226 in considering in examining the in examining legality and validity of an order of promotion is limited. Is actually liquidible. Manifest error. In the obtaining facts and circumstances of the case, it court is not persuaded to arrive at a view that the process of assessment by the selection board as well as by the appointing authority for considering the matter of promotion to the higher post of Seristada in the so and so from the feeder cadre of UDS is vitiated either on account of any biasness or arbitrariness or irrationality. Post of considering the matter in its entirety, this court is of the view that the petition or has failed to make out any case for interference and consequently the petition is liable to be dismissed. So stuff it is accordingly dismissed. I'll carry out some correction. No, if I get it reserve, it will take